So good afternoon, everyone. I'd like to welcome you to the second event in the third annual speaker series for the Center on Diversity, Inclusion, and Belonging. I'm Kenji Yoshino, and I'm the faculty director of the center. I'd like to thank the Birnbaum Women's Leadership Network, which we're so delighted began its work this year, for co-sponsoring this event, as well as the student organization Law Women, who has been a wonderful partner with us this fall as we've delved deeply into the topic of sexual harassment. And last but not least, I'd also like to thank the very generous sponsors of our speaker series who are above me on the slide: Cravath, Swain & Moore, Davis Polk, DLA Piper, Fried Frank, Kirkland & Ellis, Latham & Watkins, Paul Weiss, Sullivan & Cromwell, Wachtell Lipton, Weil, and White & Case. So thanks to all those firms for their commitment to diversity and inclusion. I'm very sorry to say that we learned less than an hour ago that Roberta Kaplan cannot join us due to a medical issue. I hope you were all informed of this either through the email that we sent out to the RSVP list or at the door. Roberta's fellow named partner at Kaplan, Hecker, and Fink, Julie Fink, will be taking her place. While we, of course, regret that Roberta cannot join us and wish her a speedy recovery, we also could not ask for a better interlocutor than Julie. Julie shares much of Roberta's background. She worked at Paul Weiss. She collaborated with Roberta on the landmark Windsor case in the United States Supreme Court. And most pertinently for today's conversation, she's worked extensively with Robbie for the Time's Up Legal Defense Fund, which provides legal representation to women who've experienced sexual harassment. In that capacity, Julie represents Melanie Kohler, who was sued for defamation by a Hollywood director after sharing her Me Too experience on Facebook, as well as a number of other plaintiffs and defendants that we will discuss. One critical difference, I was debating whether to say this, but I think I'm going to go for it, between Roberta and Julie cuts, I think, in Julie's favor, because Roberta went to law school uptown, whereas Julie is a 2005 graduate of NYU School of Law, where she graduated Order of the Coif. So please join me in welcoming Julie back to the school. So before I start my conversation with Julie, I just want to let you know how we do audience Q&A at center events. Instead of taking audience questions via microphone, we're going to do it via index card. So you will have picked up an index card on your way in. So please write your questions on the card as legibly as possible, please, understanding that my eyes are aging. As is the rest of me, but for these purposes, my eyes would be the relevant organ as they come to mind during the discussion. So helpers will walk through the room to collect the cards, and I will read out a selection from the pile when we get to the Q&A. So the purpose of this is to prevent people from dominating the conversation with questions that go on for frozen centuries of time, but also so that we can sort of curate flow of questions and bundle questions that are pertinent, are relevantly grouped together. Okay, so with that, let me begin my conversation with you, Julie. So thanks so much for joining us, first of all. I want to say, just unpack a little bit of background first. The phrase Me Too was coined back in 2006, amazingly, by civil rights activist Tarana Burke. It became a viral social media hashtag almost exactly a year ago, right, after the New York Times ran a story on October 5th, 2017, revealing decades of sexual harassment and abuse committed by Harvey Weinstein. So what's your assessment of what the movement has achieved over this past year and what work remains to be done?
Wow. Well, thank you for having me, and just echo Robbie's regrets for not being able to be here today, but I'm grateful to be able to take her spot. So it's about exactly a year ago. I think it's just been a monumental shift for women and for men. But I mean, obviously we saw it right after the Weinstein article. There were thousands upon thousands of people coming forward to say, Me Too. And we know the numbers that there are, I think we were just talking about it, 1 in 3 women is going to be a victim of sexual assault in her lifetime. And we know that, but it is different to hear the people that you work with, that you're friends with, that you admire say, this happened to me too. And that is, I think, what Tarana Burke wanted when she started that, right? So that people knew that they weren't alone, that they didn't have to be ashamed. And women shedding that shame and men shedding that shame and coming forward to say that this had happened to them and to speak their truths is just an incredibly powerful thing. We talk about it a lot, actually. We obviously talk about this a lot, and we've drawn a lot of parallels to what we've seen with the LGBT rights movement, right? Where our client Edie, I think, said it best when she was asked what caused the shift that made people feel differently about marriage equality, for example. She said, well, I think one person came out, and that gave another person the courage to come out, and then it gave another person the courage. And suddenly everybody realized they had a friend or a cousin or a neighbor who was gay and that they cared about. And it's sadly, but certainly true that the same is true for victims of sexual assault and sexual harassment. And I think that's going to have a monumental change for all of us in our culture. It's obviously going to take time. It obviously hasn't changed immediately. And there is a significant amount of work to be done to continue to allow the conversation, to encourage people to come forward, to report, and to prevent, of course.
Yeah, I love the analogy that you just drew, because when Justice Ginsburg was here last year, we asked her whether or not Me Too, in her view, would be more like, Time's Up, or more like Me Too, whether Me Too would be more like the gay rights movement, or more like the abortion rights movement. And she bucketed it in with the gay rights movement, right? Oh. Precisely because I know, right?
I'm looking at the wrong side of her.
But her reasoning was actually fascinating, because she said, women of means could always get abortions, whereas women of means can't avoid either sexual harassment or, anti-gay discrimination, right? And so the privileged cohort can't opt out of this, and it's a kind of sad reason for why you would have a movement, but be successful rather than not. But I thought it was a really interesting and valid point. So, taking us into the law, one of the reasons why we wanted to have you here, and by the way, one of the reasons I love NYU is that this is really our third conversation about sexual assault and harassment this fall. We had a center event with Commissioner Hai Feldblum earlier this year because we wanted to thematize our talks a little bit. And then when the Kavanaugh hearings broke and Christine Blasey Ford was testifying, there was an event that was sponsored by the Women's Leadership Network, which we were fortunate enough to co-sponsor on that topic, and now we get to have this, and I'm so pleased that there's still such robust attendance and interest in the conversation. But I feel like the value add that you bring is really Time's Up, right, among many other things, but that's the reason why we reached out to you, because this is really the legal arm of Me Too, right? So can you tell us a little bit more of what the Legal Defense Fund, which was launched at the beginning of the year, does? What is it? Why did you see the need for it, and what does it do?
Yeah, I think one of the things about this moment in time that's particularly important, and I'll answer maybe a slightly different question, which is what is Time's Up? Because the Legal Defense Fund is really a part of a larger movement / organization when you talk about Time's Up. When the stories broke about Harvey Weinstein, what we saw immediately was that there were women, particularly women in Hollywood, who were, had obviously a lot of social influence and had financial means, who came together and said, what can we do to practically make some change, right? It's very important to support people. It's obviously a hugely significant thing to do. But there were people that saw that they had a certain power and an ability to help make a practical change and wanted to do that. We had gotten a phone call about Melanie Kohler, who was someone who had come forward with a Me Too story and was threatened with a lawsuit and ultimately sued. And when we started just a little background on us, Robbie, we started this law firm a little over a year ago. And if you're thinking about starting a law firm, I recommend it. It's very fun. If you can do it with a civil rights hero, that's even better. And so the nice thing is that we could just say yes kind of immediately. So we saw someone who needed a lawyer and we said, yes, we can do this pro bono. But these cases aren't really cases that people would think of as pro bono cases, right? Someone who spoke out and is now a defendant, not indigent, but can't afford a lawyer. Someone very rich and powerful is on the other side. We're talking about that and how it was possible that the power dynamic that exists between most people that are victims of sexual assault makes it difficult for the movement to continue. And so one practical thing you can do to continue to allow people to say, me too, and to continue to talk about this is to ensure that they have adequate representation if they're sued, or they have lawyers they can talk to get advice before they're sued. And that was one big part of why we thought something like the Legal Defense Fund was really important. The flip side, and actually more of the work that the Legal Defense Fund does, is the plaintiff side work. And since Walmart and the US Supreme Court's decision that really limits the ability to have a large class action, if you are a low-income worker, there aren't many lawyers that see a financial upside to taking a case against a large company. And so we thought that there were really large, very significant portions of the population who weren't having, who didn't have access to lawyers, essentially, to bring claims of sexual harassment in the workplace. And the women in Hollywood who were starting what would ultimately become Time's Up had a commitment to making sure that all women, including those that had fewer means than they do, have an equal opportunity to participate and that they can make a practical change. And that's really what the Legal Defense Fund is. So I will say I've never been more impressed by a group of people acting as quickly. I think what started October 5th last year with the Weinstein article, by January they launched the Legal Defense Fund. They'd already raised $13 million. Within a month, that was $20 million. And at the one-year anniversary, at least 3,000 women and men have called the line to be matched up with lawyers around the country who've signed up to represent them. So it's really, the point of it is to really make sure that everybody has access to lawyers for this area.
That's phenomenal. It's extraordinary. What's your sense of whether or not the number of individuals coming forward, whether or not supply will meet demand, so to speak, is one outpacing the other, either the funding or the plaintiffs?
That's a really good question. I think we know there are more than 3,000 people,
of course,
right, who probably need lawyers and have claims. These are sometimes difficult for lawyers to take on, right? Because depending on what kind of work you ordinarily do, you might have a hard time being adverse, but this gives at least a financial incentive to people to do it. And I think they're continuing to raise awareness. People are continuing to call. And Time's Up itself is thinking about other policy initiatives that tackle other aspects of the law, so actually making change in the law, right? But as part of that, I think awareness of the Legal Defense Fund is a big part, and I think you'll see more of that.
Great. So the Supreme Court, in a pair of cases in the late 1990s, said that it would be an affirmative defense that employers could bring forward if they had procedures, that were open and known to individuals that could be availed of in the case of a sexual harassment suit. If they had those procedures, they could bring that as an affirmative defense in court. So in the wake of that, these are the Ellis and Farragut cases. Most employers in the United States got smart and created these policies if they didn't have them, or they made them more robust or more transparent if they had anemic ones. I think there are really two views of this, right? One is that this is pretty much a good piece of progress because you can't litigate all of these cases, as we were just discussing. At least you can't currently do it. Maybe someday you will. So it's good for employers to have these prophylactic measures in place. The other one, which has gotten a lot of traction by people like sort of Lauren Edelman out of Berkeley, is to say, this has actually done more harm than good because it's basically window dressing, and employers can engage in a box-ticking exercise of creating the procedures without actually ameliorating the root causes of sexual harassment. So, there's obviously no one-size-fits-all answer, but can you tell us, where you stand on this question and why?
Yeah. I don't think that there is one right or wrong answer, right? I think as with anything, it's one thing to have a policy, it's another thing to actually abide by that policy and give it meaning and to show that it is, serious and taken seriously by a company. There are a lot of companies that are putting policies in place and putting measures in place to do the right thing, and I think there are many that are supplementing those efforts this past year. And trying to identify what are potential kind of root causes that allow harassment to occur. But certainly I think that companies taking responsibility and putting these policies in place and working hard to make sure that they have an inclusive and diverse and harassment-free, discrimination-free workplace, that's just tremendously important, because people ultimately will look to, am I going to lose my job? And if you really think you're going to lose your job, if you're acting inappropriately, you will think twice about it in the office.
Right.
I have to hope that that's true.
Mm-hmm. One thing that was counterintuitive to me, perhaps this is naivete on my part, was how much defense you're playing, right? So I'm thinking about the Melanie Kohler case. So as you referenced, we both referenced it earlier, Brett Ratner sued for defamation after she posted on Facebook, right, accusing him of rape. A couple of weeks ago, he dropped his lawsuit, so congratulations on that. And I understand that because of that, there are certain aspects of the case that you can't talk about, although we circulated portions of the case as our pre-read. So I do want to just flag that for you in case there is something of interest that you want to raise here. Just yesterday, the New York Times reported that your firm is involved in another defamation case, this time against Moira Donegan, the creator of a list of media men whom she accused of sexual harassment. So this is fascinating, right? Because I think of the defamation claim as the kind of him too response, mm-hmm. right, to the Me Too claims that are being brought under Title VII or Title IX. So, can you just elaborate on your assessment of these claims and how much traction you think the counter movement is going to have legally?
Yeah, well, so I'll say for Moira, without getting too far into
Sure.
it, that she didn't put everybody on the list. It was kind of a shared document. Mm-hmm. But I think importantly, from where we stand, it is important that people not be afraid to come forward, right? That is what animates Me Too, right? And is raising your hand and saying, this happened to me, and it gives people the courage to say, this happened to me, and it gives people the courage to say, this happened to me. And that's an amazing thing, but when you're looking for a practical solution, right? One reason that people stay silent for a really long time is because they have personal feelings of trauma, personal feelings of shame, even though they shouldn't. We know that. But another reason is that people are afraid. They're afraid that if they come forward, especially about someone who is wealthier than they are, more powerful than they are, more influential than they are, that they're going to suffer for it. And for us as a law firm, it's important, and I think for Time's Up as a movement, it's important that we have a practical solution to that, where we say, okay, well, we're here to help people come forward. Mm-hmm. And I'm sure we will continue to see some lawsuits. I think that, look, a defense to defamation is the truth, right? So there is risk to people in bringing those kinds of lawsuits, because if they don't get dismissed early, the issue in the case is going to be, is what this person said about you true? Mm-hmm. And so there's a little bit of a built-in disincentive mm-hmm. to those kinds of cases. But I think the importance of being there to represent people like Moira is to make sure that people aren't intimidated.
So right before the conversation, I learned a surprising thing, which is that your firm also, or you and Robbie, have also been on the defendant side of this. So in the sense of it's not just that you are taking the claims of assault victims and then serving them, whether they're on the plaintiff side or on the defense side. You also have litigated on behalf of employers like Columbia University on Title VII grounds, right? So can you tell us a little bit more about that perspective? And maybe if I can put it in a more pointed way, if I'm
Sure.
coming to you as a potential client, should I be worried about the fact that, you've represented employers, right, on the other side of the ledger or on the other side of the V?
Right. Well, no. So look, I think for us, actually, we feel like, and this is a personal firm thing, right? But we feel like we have a very unique perspective. Have I lost the mic? Oh, there we go. Sorry. We both were at Paul Weiss, where most work is defense side work, and I was in-house before we started the law firm. And so we both understand what it's like to work at companies and represent companies that are working to do the right things and sometimes get sued, and some cases, you think are completely defensible, and you've got companies that are working to do the right thing. That's important, and for them to have zealous advocates is really important also. On the flip side, for people who have claims, right, it's important that they be able to bring them and that they have zealous advocates on their side. So we don't see it as a conflict. It hasn't been one for us. The cases are slightly different in type, and the type of work that we do. I wouldn't call us a plaintiff side employment firm. But I think it gives us a perspective that is maybe somewhat unique, especially in this area, because we do see some of these things from both sides.
How do you choose your clients? I mean, how do you assess your clients when they come forward? I mean, one of the hardest things, right, for a survivor of assault is that they're not believed so often, right? And so you must be in a really delicate position, even at the intake level. So how do you navigate that?
Yeah, I mean, I have to say, I don't find that many people want to lie about this. It's
Right.
it's not an easy thing to come forward. It's not fun. It's, having potential litigation risk for some of the women that have been the subjects of news articles. A lot of them are really putting their lives on the line. They're putting their families in a spotlight. And it is my experience that they're doing it for, sometimes for the selfish reason that they feel like they need to speak out. They really feel in that moment that they need to speak their truth. But a lot of times also, especially as this movement began, there were a lot of people who felt a responsibility to other women, right? That, you're sitting at home and you're so grateful for someone who's come forward about someone really more powerful, and you feel like you need to add your voice to that. And so it's really like anything else. We don't look at meeting a person who's accusing someone else of harassment or sexual abuse differently than we would a client who came in and said, here's my contract and how I abided by it. We believe people, and we talk to them, and we, figure out what cases we need to bring. We're a small firm, so we can't bring every case. But there's not. This area isn't really that different than other areas, right? There's always this question, which is, how do you know who to believe, or how do you, there's people come and talk to you, and you generally believe them.
Right. Yeah, that's helpful. Speaking of civic duty and national spotlights, you represented Elizabeth Razor, the college girlfriend of Mark Judge, the man alleged to have been in the room with now Justice Brett Kavanaugh when Christine Blasey Ford was sexually assaulted. So can you tell us a little bit about the experience of representing Ms. Razor and your impressions, I'll put this as delicately as possible, on how your allegations were handled by the Senate Judiciary Committee?
Well, look, I think it's public that she offered to be interviewed. Someone else who wasn't looking for a spotlight but felt like it was important to speak. And I think it's fair to say, I can speak for myself, but I wish that the confirmation hearing had gone a different way on many levels, and that there had been a fuller investigation from the one that we saw. It's really, yes.
Yeah, perhaps there's no more to be said. Let me broaden the lens a little bit. So based on your observations of the Kavanaugh confirmation process, what progress, if any, do you think we've made since the similar standoff between Anita Hill and Clarence Thomas in 1992?
Yeah. I think the easy answer is not enough, right? It's funny, we had a group of people, we had about 40 women come together a few nights ago from different areas and different occupations to talk about how they were feeling. It was like I want to say it's like an old-fashioned consciousness raising, except I've never been to one and I don't actually know what that is, but I'm told that that's what I attended, an old-fashioned consciousness raising. And it was really interesting for me to be there, because sort of one person would speak and talk about why they were hopeful, and then one person would speak and talk about why they were despondent, and then someone else would talk about how the progress that we've made, and then someone else would talk about how we surely haven't made enough progress, and people were crying and people were talking about their own experiences. And I just think that all of those things are true, right? This is disappointing, but it is also in a moment where we are making so much change and so much progress. And I'm not always a glass half full person, but I mean, we are somewhat in the middle of it, so I see a lot of what's going on with Time's Up and Me Too, and I'm really moved every day by the courage of people coming forward and the commitment of people from Time's Up and elsewhere that are working to help them, and the importance of the conversation, that we're still having the conversation. And I think that that's progress, and I don't think that Genie is going to go back in the bottle. And we were reminded by a very wise rabbi who was there with us that the path to progress is just never a straight line. And there's always setbacks and there's always disappointments. And it doesn't mean that we're not overall moving forward. And so that is my hopeful take on it, that I think the work we were doing 2 months ago, we're just going to double that effort and make sure that we continue to remind people that women should be believed and continue to think about practical ways of ensuring that that happens.
You mentioned your incredible work on the Windsor case. You're too modest to call it incredible, but it was just such a phenomenally litigated case. I wanted to take the occasion of your kind of dual tranches of expertise to talk about a intersectionality issue between LGBT rights and sexual harassment. So we've talked about them as parallel movements, and I want to kind of bring them together. We know that LGBT individuals sort of suffer on both sides of the sexual harassment equation. So Janet Halley, the legal scholar, has talked about how gay individuals or queer individuals are much more likely to be accused wrongly of sexual harassment because people, take statements like, my husband and I went to the movies last night, to be a form of sexual harassment in the workplace if you bring it up as a topic, right? That you're flaunting or bringing up sexuality in the workplace in a way that makes them uncomfortable. On the other hand, right, on the other side of the ledger, unfortunately, we also see that LGBT individuals are disproportionately targeted for sexual harassment. So a recent study that was published out of Harvard just noted a remarkable disparity between straight and gay individuals, for example, with regard to the incidence of being targeted for sexual harassment, right? So any thoughts on how to ameliorate this and draw more attention to this issue?
It's a really good question. I don't know. I mean, I think it's like everything else, right? That we need to talk about it. I think it's something that for companies and for people that are thinking about what policy should look like and how you approach it, it's something that just needs to be part of the conversation, right? Intersectionality is, and the multiple different facets of it, whether it's race or it's sexual orientation or it's ethnicity, they all play a role, unfortunately, in our experiences in the workplace, our likelihood of being harassed, our likelihood of being assaulted. It's just, unfortunately, I think a fact of life. And I think that the important thing to do is to make sure that we are focusing not just on, what's the experience of women, but what's the experience of trans women, or what's the experience of gay and bisexual women. And similarly, when we talk about women, it's how does this affect a woman who's a person of color, and so forth.
Mm-hmm.
Everybody, we just know that the prevalence of these issues, it is impacted by all these different factors.
Right. Do you have a theory? Like, I mean, Hallie has a theory about why gay people are targeted wrongly on the harasser side, which is that, as I mentioned, our sexuality becomes more visible, right? Do you have a theory about why they are more targeted on the harassee side?
On the harassee side?
Yeah.
No.
Okay. Fair enough. Yeah. It just struck me listening to you. I want to talk.
Well, I guess I'll say this, and
Yes,
this
please.
is like purely, and this is a non-expert opinion, to the extent any of these are expert opinions. But look, I think that some people would say that for people who are LGBT, your sexuality is part of your identity,
Right.
which doesn't really make any sense, but it just seems to be for people. So I had an interesting conversation with someone once, we'll just take this as a total aside, who was talking about how she thought her experience as someone who's bisexual was different than the experience of someone who's gay. And that her perception was that when she talked about being bisexual, it always seemed to other people that she was talking about her sex life,
Mm-hmm.
right? And somewhat kind of the way that you say about being accused of being the harasser,
Right.
That people are affiliating you in some ways with your own sexuality, regardless of what your sexual orientation is. And probably on both sides of the coin, that makes you more likely to maybe be perceived as approaching someone in a sexual way, even when you're not.
Right.
And maybe you are either victimized in a way that's more sexual than you might be otherwise, or you're approached in a way that's more sexual than you would be otherwise.
Right.
But that's a guess.
Yeah, I have an even darker iteration of that. I mean, we can pursue this offline. But in South Africa, there are accounts of so-called corrective rape, where women who are perceived to be lesbians are raped in order to sort of guide them back into heterosexuality, right? And so that's an even more macabre form of the motivation behind that. Yeah. So let me take us to a less very, very dark place. You're a litigator, right? But of course, the Me Too and Time's Up movements are not just about litigation. So one of the things I think you have been very good at, both in the Windsor litigation and this litigation, is to make sure that it's not just litigation, right? So you're very active, whether it's social media, whether it's being in the New York Times or what have you, right? So how do you view the kind of cultural fight and the legal fight overlapping? Like, is this primarily understood as a cultural movement where the law is the last line of defense, or is the law playing a more central and integral role in the cultural movement?
I think it's both. I don't think that there's, people ask me the question, whether it was about when we were focusing on marriage equality and civil rights for LGBT people, or when we talk about women's rights, what's the best approach? Is it political? Is it social action? Is it media? Is it cultural? Is it legal? I think it's just everything. It all pushes things forward in the same way, right? So sometimes in some places the law is a little bit ahead, but frequently it doesn't get there until people in the community are ready to recognize that LGBT, marriages of same-sex couples are really the same as marriages between different sex couples. I think you really need all of it happening at once. I think the law, obviously, is just a very important tool that we have to protect people. But I think that the cultural recognition, I mean, right now, right, with Me Too, with Time's Up, it is a cultural movement that's being aided by the law. And it's one where the law should be protecting people, right? I mean, this seems obvious, but I feel like I keep saying it lately. Sexual assault is a violent crime, right? These are people who are victims of a violent crime, and our legal system is there to make sure that they have relief, but they don't feel, sorry, I'm buzzing. People not feeling like they have an outlet in the legal system, or they don't feel safe to come forward in the legal system, whether it's criminally or civilly, is incredibly unfortunate and needs to change. And part of that change is going to be cultural. Mm-hmm. And as more people do it, there'll be changes in the law. And as the law changes, the courts will keep up. And I just think it all has to happen at once.
Great. I'm struck again, and just comparing the movements. Joe Biden once said on the culture versus law question, like Will and Grace as a TV show did more for gay rights than any litigation did. And I'm wondering what the equivalent would be in this context, given that you're not going to make a comedy about sexual assault, right?
Yeah. It's
so what is the...
It's funny, this will make me feel young, because I was always like, well, we're here because of Glee. So I feel young. It's funny, I don't know the answer. I think what we certainly see is that with the women in Time's Up, these are women in Hollywood who are recognizable. It's not on the sitcom that we watch every day, but these are people that we culturally admire and look to, who are saying this is happening and this is important, and I want to use my platform to bring attention to it. But I was just thinking this the other day. I mean, we should see it more. It's not a fun topic.
Yeah.
But we should see more of this reflected in our culture back to us, because it is so prevalent.
Yeah.
Right? And if you are watching TV shows or movies and you've never seen a victim of sexual assault in TV shows or movies, then it's not really reflecting our reality. Mm-hmm. Now, they also don't represent women equally, and there's whole lots of issues with the media. But it's like we were saying earlier, I think recognizing that we all know and love people who are victims of sexual assault and sexual harassment, it's an important thing to acknowledge. That's not what it should take for us to care about it, but it is an important thing, I think, for us to acknowledge and recognize a pervasive problem in our society so that we can make change.
Right.
And it is so pervasive that it should be reflected back.
Yeah. I'm going to riff off of the fact that you anchored on Glee rather than Will and Grace to ask a generational question. And this is my last one before we turn to the questions from the audience. So you graduated from this law school in 2005. You've had an amazing career, right? I mean, you've lived greatly in the law already. So you worked at Paul Weiss, you went to Pfizer, and now you're doing sort of path-breaking work in civil rights, right? And that's actually a through line. I think it sort of scants the tale to say that you started civil rights when you started with Time's Up, because you were working in the Windsor case, I believe, back when you were at Paul Weiss even,
yep.
Right? Yeah.
Yep.
So if you were facing a group of young law students from your alma mater today, like what advice would you have for them as they grow into becoming young lawyers?
I would say, my best advice is, this is sort of general advice, but kind of my slogan is that you don't get what you don't ask for, and you'd be amazed what you can get if you ask. So when I was a law student, and I think I came here wanting to be a corporate lawyer, but I didn't know what that was. And then I spent a summer doing corporate law, and that seemed really boring to me, but it's wonderful if you're interested in it. And then I spent a summer doing litigation, and I realized I really, really enjoyed it. And I knew I was going to go to a law firm, but I was interested in civil rights work. It's why I went to law school. And the reason that I went to Paul Weiss was because I had seen a person who had come to NYU and spoken on a pro bono panel about work they were doing there. Her name is Maria Vullo, and she was talking about work she had done for Planned Parenthood, and a lawsuit that she'd brought against these individuals who were essentially threatening doctors who provided abortions. And she was the reason I wanted to go to Paul Weiss and I wanted to do work there. And when I went there, I just told someone. I was like, this is what I want to do. And then I was asked to do more work. I was very busy, but I was asked if I wanted to do a case with her. And I said yes, even though it wasn't the pro bono case that I wanted to work on. I said yes. And then at the end of it, she said, I should have asked, but she said, do you want to come work on Planned Parenthood? And I said, yeah. And it was my first kind of big dream come true. I'm working on a cert petition to the Supreme Court on an issue that's really important to me. and it got me really engaged in doing pro bono work. I was really lucky to, be asked to join the Windsor team right when Edie came to Paul Weiss. But also that was because Robbie, when I came to the firm, I knew that Robbie had done the marriage case in New York. And I told people that I wanted to work on it. And then when this new client came in the door and it looked like Robbie was going to take on the case, someone said, hey, you should call Julie. I think she's going to be interested in it, and she's probably the right level that you need. And I got involved with that and then some other matters. And so I think if you want to do it and want to make it a part of your career, most law firms, it's really important. And you just have to find a way it sometimes requires doing extra work. But it is, I think for so many reasons, doing pro bono work at law firms is just such a wonderful thing for your career. I think at one point I said, if you're going to spend so much time and so much personal energy devoted to work, it's like therapy to have part of it be for something that you care really deeply about. And you also get lots of practical experience. You get to represent clients in a way that you don't with large companies. So I think it's sort of doing the work.
Yeah. Gotten some great questions. So I've bucketed these first 4 out into the kind of legal nuts and bolts litigation category.
Okay.
So
The tough
pretty rapid fire, right? So what's the profile of lawyers who are taking case referrals from Time's Up LDF? Are they mostly solo practitioners, small firms with relevant expertise, or are they pro bono lawyers from large firms?
That's a really good question, and not one I think I know the answer to. I think that most of the firms, I think there are a lot of large firms that want to get involved in some way with Time's Up. I'm not sure how many large firms are actually part of the network for Time's Up. I'm just looking at Olivia, who works with us on all of our Time's Up cases, for like a nod that I'm getting this right. But I think a lot of the people that are doing it are at small shops.
The big firm pro bono would presumably do it pro bono, right? So they wouldn't be drawing on your funds, or is that not right?
Well, that might be right, but Time's Up has a referral process, so you don't necessarily need to get funding or even apply for funding to work on a case through Time's Up. Somehow that's just how you can find a matter.
Okay. So this is also a litigation question. How do you litigate the kind of nuances of sexual harassment, like coerced consent in quotes or verbal commentary? I assume that's a reference to the stray remarks, doctrine. So many harassers know how to play into this gray area, right? So how do you handle that? And if they don't know it, their lawyers know how to do it. So.
Yeah, I mean, that's a tough one to answer. I think at the end of the day, like anything, you're preparing a case to go to trial, and you're trying to figure out how a judge and then ultimately a jury will understand what's happening, and you just have to put all of the pieces of it together and make your showing. And there's obviously there's standards and burdens in case law that you can point to, but if there's a pervasive set of activities or conduct and they all point in the same direction, you're just going to have to persuade a jury of that at trial ultimately.
Great. Over the past year, there have been numerous federal and state legislative proposals that would ban or at least limit the enforceability of non-disclosure clauses in sexual harassment cases. Right? So notably, these bills do not limit NDA usage in other harassment cases. So why is there a distinction between sexual harassment and other forms of harassment? And I think this is particularly a neat question because you've at several points in this conversation said, let's not treat these cases differently. So when I asked you the intake question, you said this is like any other intake.
Yeah.
When I asked you another question that had to do with sexual harassment, you said sexual harassment is a violent crime, so we should look at it through that frame. So why is an NDA in a sexual harassment case different from an NDA in a racial harassment case?
I don't think that it is.
Okay, so you're at the...
I don't think that it is. I think people are... So
maybe the question is, why do legislatures think that it is?
Yeah, I mean, I think that you have a lot of people that are responding to something that is, again, because of people coming forward, this is an important topic and it's what we're talking about. We could and should be talking about all the other forms of discrimination that are problematic and all the other forms of harassment that are problematic. But we're having a moment where we're talking about the experiences of women, which is really important to focus on also, right? And so people are responding to that. I have lots of different and maybe nuanced views on whether banning NDAs or the way that they're being handled is the best idea. I'm not sure what the answer is, but why we're singling out one form of harassment over another, I'm not sure that there's as much of a distinction that makes sense, except that we know about the prevalence of sexual harassment, and we know that it's a problem that we really need to deal with.
Similar question to the two back. As a litigator, how do you grapple with a client who has been harassed but has not always sort of pushed back or demonstrated unwelcomeness as clearly as would have been ideal for a plaintiff?
Yeah, I mean, I don't have a great answer to that other than this is what these cases are like, right? There's no perfect case where someone's harassed and they go to, I mean, there are, I guess, perfect cases, but most cases are complicated, and most situations are, you may say as a lawyer, oh, I wish this person on either side had done this, and this, but in reality, people do this, and it's something that you always have to deal with in every kind of case.
I was going to leave this out because I've vetted the gay rights stuff a lot, but I can't resist giving your response to the no perfect plaintiff. If the gay rights movement is a proper analog, what would be the ideal landmark Me Too case akin to Windsor? What principles of law would you want it to uphold? And I guess I would, as a writer, what would the ideal plaintiff look like?
Yeah. That's an interesting question because you've been around long enough to know that Edie herself was by most people not considered to be a perfect plaintiff.
Right.
Edie, in fact, had gone to lots of places about bringing her lawsuit after her spouse Thea had died, and most people turned her down because they didn't think she was a very good plaintiff for a marriage equality case. She was wealthy, she was white, and there had been, I think, a general consensus that for a lot of these cases, a lot of civil rights groups wanted they would have lots of plaintiffs in cases. So you'd see multiple couples, for example. You'd see couples of different income, often low income, different races, different ethnicities, to show, I think, in some ways how the bar on marriages between same-sex couples was really hurting people, right? And when we met Edie, what we thought was, man, she is like everyone's grandma, but like the coolest grandma you could imagine. And she has a love story that's just so enviable and amazing. It's what you want a marriage to be like. And yes, she's got money, and yes, this is an estate tax issue, but also conservative people don't like taxes, so maybe that'll help. And as it turned out, she was just a brilliant person, and she could communicate about the unfairness of the Defense of Marriage Act better than any lawyer. You just felt it when you talked to her, that she'd been with someone for 40 years, and then she had to sit with an appraiser and talk about who owned what chair, which is absurd. And so Edie was the perfect plaintiff just because of who she was and the way that I think people related to her. I don't know who the perfect plaintiff is for a sexual harassment case, but I'm guessing it's someone who looks like someone you wouldn't think is sexually harassed, right? When you see successful people, right, who made it pretty far, who are well educated, who seem to have it all, and then you learn that they were a victim of sexual assault and they never reported it for a lot of reasons, and they've been victims of sexual harassment and they haven't reported it. It makes it, I think, a little bit more relatable, but it's a bit of a guess.
Great. How can non-litigators, right, i.e. corporate attorneys, get involved and give back?
I just poured water on myself. Sorry about that. There's lots of ways of giving back. I mean, transactional work is like 90% of legal work. And in part, you have all these organizations that are setting out to help people that need advice organizing and raising money and figuring out how to do all that. That's one way to get involved. It's also, I would say, sometimes it helps to do public interest work that's maybe outside of your area of expertise. So just because you're a bankruptcy lawyer doesn't mean that you can't work on a litigation matter, depending on your firm. But there are great organizations also that focus on transactional pro bono work, like the Pro Bono Partnership and other groups around New York. I think there's lots of ways of giving back.
Good. In case it wasn't clear, I've moved on to the non-litigation solutions bucket, of my buckets. So this is a great one. Have you seen a good approach in working with organizations to root cause intervention by an employer? If so, what was it? If not, why do they always fall short?
I don't know that I have an example of that. I can pat us on the back, and I can talk about something that we did, which I'm not saying other people can follow, right? But for example, like we had so we're a new firm, and we had an associate with us who was going to go to a clerkship. She's now at her clerkship, and she found out shortly before she was going, maybe a few months, that she was pregnant. And there was no maternity leave option or parental leave option in the federal courts. And so she wasn't quite sure how it was going to work for her when she started her clerkship. And this is also the fun thing. Again, I recommend if you want to start your own firm, you do it. We talked about it and her concern, and we said, well, just we know what it's like. I don't have kids, but like I see what it's like for people who want to have a family and feel like they're penalized for it, or that they either have to make choices between being home or working. And it's something as a law firm for us, forgetting about our external work with other clients, we want to avoid, right? And so we ended up working out a solution with her and her judge, where we have another really talented associate at our firm who wanted a clerkship, who we thought would learn a lot from that judge. And we said we would give her the time off to work for the judge while she was off with her newborn. And we're going to be doing that in a couple weeks. Well, maybe 3 or 4 weeks that she'll be going. And as an employer, because I'm an employer now, which I never thought was going to happen, I'm really proud that we did that, right? Because it's something different than just having a policy that says we don't discriminate against people based on pregnancy or gender. It's different than just kind of trying to tackle something after something bad's happened, or when you're trying to figure out how to avoid it. Like, it's really thinking, okay, here's someone whose career might be impacted. How can we look at it? And as an employer, and when we work with other companies, and as we sort of are in the room with people who've got a lot of experience working on different policies, it's very exciting to talk about how you can think about those kinds of changes. I think it honestly has to come from a genuine commitment to wanting people to have an equal opportunity to succeed, which means that they're not going to be a victim of sexual harassment or racial harassment. It means that they're not going to be subjected to unwanted advances, and that they're not going to be penalized for being a parent.
Do you see any relevant differences? This riffs off of a question about law firms. Can you touch on gender issues and sexual harassment in law firms? Do you see any difference between how law firms deal with sexual harassment and the prevalence of sexual harassment in law firms as opposed to other industries?
I think lots of industries are different, right? I mean, law firms are just interesting places because their ownership is so broad, right? There's so many people that have a stake in the place. It's been a long time since I've been at a firm. But I think kind of every industry, because they're all set up differently, whether you're like a large public company, like a place like Pfizer where I worked, or if you're a startup like where I am now, or if you're a large law firm, just the dynamics of how you run requires you to really think through how you're going to tackle these areas in a somewhat bespoke way.
Great. I love this question. These questions have been terrific, by the way. Thank you. This is about language, right? Language is really important, right? And we need to stop talking only about victims, right? And how assault happens, which is a passive formulation, and start speaking more about men assaulting women or people, right? It seems like we speak of this issue only as what happens to women and men, and not sort of in the active voice. So can you, either on that issue or more broadly on the language issue, and working with Time's Up, has your linguistic practice changed in order to capture the realities that you see?
Probably not as much as it should. I mean, I just learned the
I
word
was just-
intersectional like 2 years ago.
Yeah,
Um,
scrolling back over this
yeah,
conversation to think
exactly,
about how
me
I've
too. I'm
talked
like,
about
what did
it.
I say?
Yeah, yeah.
I think those things are important. And it's, like I said this at the beginning, I think that when we think about Me Too and Time's Up, it's easy to, like, well, not maybe easy, but sometimes I think there's a focus in this moment on people coming forward and speaking out about things that have happened to them and people who have done bad things to them, and how they're held accountable and the kind of relief that they get. But the most important thing, and it's important to remember, is that what we want is for it to stop. And I do think language is going to be an important part of that. I just think having this conversation, right? It's prevention, right? It is holding people accountable. It is coming forward. It is being comfortable speaking up. But it's also making sure that it doesn't happen and speaking to your children about it. I'm getting a Time's Up sign. And so I do think language is important. I think the perspective is important too.
Right, great. My wonderful executive director is holding up signs because he knows I tend to run over time when conversations like this happen because they're so interesting. And I'm sorry we won't get to all the rest of the questions. The sign he held up was a Time's Up sign, appropriately enough. So will you please join me in thanking Julie Fink.
Thank you.